Well, good morning, and appreciate the opportunity to be a part of the conference program this year. I think we spent a lot of time over the last day and a half talking about employee safety issues. It's a really important topic. This is a shift in topics. Now we're going to talk about food safety issues, which are becoming more and more prevalent within our industry, whether you're a grain handler, grain processor, animal feed manufacturer, whatever the case may be. FSMA is really a game changer, and so what I want to do over the next few minutes is provide an overview of FSMA in general, and then hopefully narrow down into some nuances that have been created within some of these rules and how they impact you folks and your facilities here. A little bit of background, just so that we're all on the same starting point here. We've been talking about FSMA for a long time. Signed into law back in 2011. It did really fundamentally change how food is going to be regulated within the United States. And when I'm talking about food, I mean raw agricultural commodities, I mean animal feed, I mean ingredients used in animal feed, human food. So the definition of food is quite broad, and that's probably why we're here today talking about this. FSMA does mandate that FDA create a number of new regulations. Going to provide you an overview of what those regulations are, and then again, hopefully provide a few nuances about how these new requirements apply in certain situations. First of all, I just wanted to remind you that FSMA also provided FDA authorities to do some new things. One of those new things was to require food facilities to re-register with FDA every 2 years. So for facilities that manufacture, process, pack, or hold food, those facilities are obligated to re-register as a food facility with FDA on even-numbered years during the last quarter of those even-numbered years. So here we are, it's 2016, it's an even-numbered year. So if you have a food facility, you need to re-register with FDA during sometime between October and December 31st of this year. So get it on your calendar, get it done. It's a free process. I'd encourage everybody to do that. I've also listed a couple other authorities that FSMA provided FDA. One is they now have the authority to issue mandatory recall notices. So if a facility has distributed a food that FDA believes is unsafe, and if the facility is unwilling to voluntarily recall that food from the market, FDA now has the authority to mandate that you do so. I certainly encourage you not to get in a position where FDA mandates that you recall food. It's not going to be good for you. It's not going to be good for FDA. It's not going to be a good experience. And then finally, the last authority that I've listed here is that FSMA allows FDA to collect fees in certain situations. One situation would be if FDA came in and inspected a facility, found what they believe to be violations that require official actions, and they need to come back to re-inspect that facility to assure that those conditions have been addressed. They have the authority to collect fees for that re-inspection activity. The current hourly rate for those re-inspection activities is $217 an hour. So FDA hasn't used this authority yet, but I think it's only a matter of time when they'll start using it to help fund their activities. I'm asked often by this type of group, well, does OSHA issue fines? Or excuse me, does FDA issue fines? And the answer is FDA does have civil penalty authority to issue fines for violations, but in my experience, they've never chosen to use that authority. Typically what FDA does, if they find a violative product, they'll stop sale of the product, they'll withhold distribution of the product. If something's egregious enough, they can actually pull a food facility registration and in essence prohibit them from distributing food products. But typically FDA does not use monetary fines as an enforcement method. I mentioned that FDA under FSMA is mandated to promulgate a number of new regulations. This slide lists those 7 regulations, those 7 major regulations that FDA has finalized. I've highlighted in red font and italicized those that specifically have application to animal food facilities. But I guess the point I want to make is all these rules are final, and they're going to impact our industry in one way or another. First thing to ask always when there's any type of rulemaking, including FSMA rulemaking, is who's in, who's out. There's always exclusions made. There's always exemptions provided. And so let me just walk through these major rules and provide a little bit of a high-level view of which rules have applicability to certain types of facilities. So generally speaking, FSMA applies to facilities that are required to register with FDA as a food facility. If you're here today, I'm going to guess that you have facilities that are required to be registered as a food facility. So you need to pay attention to these FSMA rules and understand what the requirements are and which ones apply to you. There are exceptions to this food facility registration trigger. So for example, if you're an importer of foreign food, that rule applies to you, whether or not you need to register with FDA as a food facility or not. Also, there are some aspects of the sanitary transportation of food rule that apply to entities that are not required to register. So we'll get into a little bit of detail about the sanitary transportation of food rule later. Farms or operations that meet FDA's definition of a farm are exempt. We could spend a long time talking about the farm definition. Thank me that we are not going to do that, but farms are exempt. If you raise animals, grow food, harvest food, those are generally the primary activities by which an operation would meet FDA's definition of a farm and therefore be exempt from FSMA. And then finally, various rules provide certain modified requirements or exemptions for certain types of facilities. So let me walk through these 7 big rules, again at a very high level, trying to draw out some nuances in terms of how they apply to facilities in this room. First of all, the human food and animal food CGMP and preventive control rules. Facilities solely engaged in storing grain and oil seeds are exempt from both rules. So the solely engaged definition comes to play, and also the grains and oil seeds definition comes to play. On this slide, I've highlighted that if you have a facility that's involved in holding fruit, then that situation is kind of unique, and the way the rule is constructed, that type of facility would be exempt from the CGMP requirements, but would be covered by the preventive control requirements. I'm not going to get into the details there. It seems wacky. It is wacky, but that's the way it is. And so I've listed some raw agricultural commodities that FDA, from a scientific standpoint, characterizes as being fruit. So you can see those listed on this slide. I'm not going to go into that. But if you have a holding facility that's involved in storing one of these fruits, then you need to be aware that the preventive control requirements within these rules apply to you. Certainly, if you're a grain miller that processes human food and potentially sends a co-product to animal food, you could be covered by both of these rules. And then if you're here representing a facility that's involved in distributing animal feed, pet food, you'd be covered by the CGMP and preventive control rule for animal food. Let me get into this solely engaged topic in a little bit more detail. And so there's lots and lots of words on this slide, but the point I'm trying to make here is that the solely engaged in holding, the holding definition encompasses virtually any activity that a grain elevator may perform. So what I'm saying is you can perform all the activities that you normally do in a grain elevator, still meet the holding definition, and still be exempt. A number of those activities that FDA cites as being incidental or part of the holding definition are included on this slide. So things like drying grain, fumigating grain, cleaning grain, and even distributing those cleanings as a feed ingredient. All those activities FDA believes are included within the holding definition. So if you're a grain elevator, you can perform those activities and not negate your exemption. You're still exempt from the CGMP and preventive control rule. There are some nuances, though, about this solely engaged in holding topic. So the grain elevator exemption would apply when holding grain is the only food-related activity at that facility. So the exemption is not clear when you have a facility that's engaged in holding grain and also some other food-related activity. So For example, if you had a grain elevator plus a feed mill at a facility, or a grain elevator plus a bag feed warehouse at a facility, or a grain elevator plus a transloading operation at a facility, the exemption is not so clear there because the facility as a whole is not solely engaged in holding. I have posed questions to FDA about these and other scenarios, and I'm still waiting on a response from them in terms of their interpretation of the compliance obligations that would be associated with these types of, I'll call them mixed facilities. So we're still waiting to see what's going to happen in that regard. So the question was, what about putting grain in bags? My view of that is that's a normal distribution process associated with holding grain. So performing that distribution process would not negate the exemption that's been provided within the rules. The question was, what about the transloading operations? So transloading, different people maybe have different definitions, but you're receiving a food, transloading it onto another conveyance. Really, transloading operations in FDA's view are transportation activities. We're going to get into that a little bit later when I talk about the sanitary transportation of food rule, but that's what I'm talking about when I mention transloading. You've got an operation occurring at a facility where food's coming in, it's being conveyed into another conveyance, and then it leaves. It's stored in between, then you're holding food. Okay, so let me try to repeat the question. We've got grain coming into a grain elevator by truck. The grain is stored. The grain's loaded onto a rail car. How would that activity be characterized, in terms of what I'm talking about here?
Is it exempt or non-exempt?
That activity that I just described would be exempt if that's the only activity going on at that facility, food-related activity going on at the facility. I was here earlier this morning. We had this question going on about what's a facility. That question is coming up more and more as these FSMA-related rules are being implemented. I think, back the facility registration requirement came about back in 2002 when the Bioterrorism Act was put in play. And at that time, there were not a lot of regulatory requirements associated with food facility registration. But as time has passed, more and more requirements have been specifically tied to food facility registration. So I would encourage everybody to take a strong look at how you're registering your facilities and make sure you're doing that appropriately. FDA's definition for facility is generally all the structures, buildings, activities that occur under one ownership in one general location. That's their definition. That's my paraphrase of it. So I've seen some folks suggest that, well, if you're creative enough in your food facility registration, you can somehow avoid some of these regulatory requirements. I'm not your legal counsel. I'm just telling you that try to understand your obligations under food facility registration and register your facilities accurately. For example, again, I will go, maybe I'm going to go a little bit too far here, but if you have a facility in one general location under one ownership and a grain elevator is part of it and a feed mill is part of it, I think you're going to have a hard time justifying to FDA that those two operations would constitute two separate facility registrations. Good questions. Let me move on quickly. Anybody here an importer of food, foreign food? One sole hand went up that I saw. Certainly, if you're an importer of foreign food, you need to be aware of the foreign supplier verification programs. If a grain elevator is an importer, they need to comply with the foreign supplier verification program requirements. There's no exemption for grain elevators from the foreign supplier verification program requirements. Accreditation of third-party auditors only applies to foreign foods in certain situations. I always take the opportunity at this point to say that really nothing within FSMA, aside from this certain circumstance, requires you to enter into a third-party certification program. There may be many good business reasons for you to do that, but FSMA does not require food facilities, generally speaking, to participate in third-party certification programs. The sanitary transportation of human food and animal food rule applies to grain feed facilities involved in truck and rail transportation. We'll get more into that in a little bit. And then the food defense intentional adulteration rule applies to human food. Animal food is exempt. Grain elevators are exempt. And I don't think we as the NGFA did a big enough job in tooting our own horn here in obtaining an exemption for grain elevators from the food defense and intentional adulteration rule. If you weren't aware of that, that's a big deal. So I'm going to make you aware of that now. Okay, let me move on and dig a little bit more into the CGMP and preventive control rules. And I'm going to focus on animal food, but the human food rules constructed in a very similar manner. And so it was issued back in September, contains a number of subparts. I get asked frequently, well, give me a checklist on how to apply. And I'm going to say that this is not a checklist regulation. These are complicated, and if you're covered by the rules, you're going to need to take time to understand what the requirements are. Generally speaking, facilities who are covered by any aspect of the rule need to have qualified individuals employed or working at their operation if they're engaged in holding, processing, manufacturing, or packing of food. This requirement extends to contract employees, seasonal employees, anybody that works at your facility engaged in holding, processing, manufacturing, packing of food. The requirements are that those individuals need to have the training and education necessary to perform their activities to ensure safe food, and then also receive training in the principles of animal food hygiene and animal food safety. That needs to be documented training. This is a new requirement for our industry, and so you need to be aware of it, and you need to conduct food safety training for employees that are covered by this requirement. CGMP requirements at a high level establish new provisions for covered facilities. Human food facilities had CGMP requirements for a long time. The animal food CGMP requirements are new. So if you're a covered facility, you need to be aware of what these requirements are. Nothing really went away. Any current requirements that you currently have are still there, but the CGMP requirements apply to all covered facilities. A few perspectives on the CGMP requirements. I mentioned before people want a checklist. Well, here you go. The CGMPs consist of 85 different provisions. There's your checklist at this point. You can work through those provisions and see how they apply to your facility if you're covered. A lot of these provisions have this wiggle language in it. Things like suitable, adequate, when necessary, where appropriate, things like that. And the challenge that FDA had within this rule is they tried to draft a rule that would cover the scope of the types of operations that the animal food industry encompasses. And so if you're familiar with animal food, FDA has this strong aversion to biological contaminants in pet food. It's things like salmonella in pet food or listeria in pet food. They're not so much concerned about that when it comes to livestock feed. And so we have these CGMP requirements that were constructed to fit both these situations where biological contaminants are a concern and in other facilities where they're not. And so it's going to take time to understand what these these provisions mean. But some are clear, some are not clear. We'll work that out over time and as FDA issues guidance. The preventive control part of the rule is really, it's this idea that somebody qualified at a facility needs to do a hazard analysis. And for those hazards that are identified as being really significant, the facility needs to implement a preventive control to significantly minimize or prevent that hazard from causing food products to be adulterated. A written food safety plan needs to be developed as part of these preventive control requirements. So the outcomes of the hazard analysis really drives compliance obligations under the preventive control part of the rule. If you do this hazard analysis and are able to justify that you don't have any of these bad hazards requiring a preventive control, your compliance obligations are pretty limited. But if you do this hazard analysis and determine that, yes, you do have these hazards that require preventive control, then there's a pretty extensive record keeping and documentation that needs to be put in place to demonstrate that you're controlling these hazards adequately. If you're familiar with HACCP, preventive controls are kind of like critical control points, not exactly, but kind of like critical control points. And if you identify the need for preventive controls, you're going to have to institute those management components, things like monitoring, verification, validation, record keeping, corrective actions, things like that to ensure adequate control of the hazard. And a preventive controls qualified individual needs to develop and oversee the written food safety plan if it's required. So a few nuances here about how grain elevators fit in with these CGMP and preventive control requirements. We've already talked about this solely engaged thing. If you happen to be a facility that's handling fruits, the GMP part of these rules do not apply to you, but the preventive control parts do. You're going to have to work through that. Facilities that only hold food, like grain or fruit, are not defined to be suppliers by these two rules. I point that out because I get a lot of questions about, from member companies. People call me and say, well, my customer says FSMA tells me I need to do this for them. And that's not true. You may have certain obligations under the rule to follow, depending upon your operation, but in no aspect does the rule require you to do something for your supplier, or your customer, excuse me. So that's going to be a business decision, just as it's been in the past for you, how you want to address those concerns. Some other perspectives about the preventive controls requirements. If you do fall underneath this part of the rule, everything there needs to be documented. I mean, everything. Everything has to be written down. Obviously, the idea of when does a hazard reach this level of requiring a preventive control is a big deal. We're going to have to work through that with FDA to gain a better understanding there. And what level of documentation is going to be needed. If preventive controls are needed, how are we going to work out and how are we going to validate them? So I think there are a number of issues that we need to address yet, and FDA is going to issue guidance on some of those issues. You know, it's taken us almost 5 years to complete the rulemaking process. It's going to take us many more years to understand what the words on the paper mean. So we're going to work through that just like we do when we get any new regulatory requirements. One thing I did want to mention to you, if you are a facility that's covered by the preventive control requirements, the NGFA and the American Feed Industry Association has funded a study at the University of Minnesota to kind of conduct a generic hazard analysis that could be used as a starting point for the hazard analysis that need to be performed under the preventive control requirements. So hopefully that information will be coming out, made available to the industry in November. That's our target date anyway. Another thing I wanted to mention to you was the Food Safety Preventive Controls Alliance. If you are covered by the Preventive Control Rule or the CGMP and Preventive Control Rule for animal food or human food, the Preventive Control Alliance has worked to create a number of materials that I think could be beneficial to you in understanding what the requirements are and how to meet them. The Alliance is really a private-public partnership. Trade associations, the NGFA has been involved since its inception, land-grant universities, and also the regulatory community. And one of the main deliverables is to produce this standardized training curriculum for the CGMP and preventive control rules that I was talking about. And then successful completion of training under this curriculum is one way to become one of these preventive controls qualified individuals that is required to develop and implement a written food safety plan. Individuals may also be a preventive controls qualified individual because of their job experience. But this training curriculum that's been developed is one way to gain knowledge necessary to build one of these written food safety plans. I also wanted to point out that the FSPCA is developing training materials for the Foreign Supplier Verification Program rule and also the Food Defense rule. So I think some facilities here may be impacted by the Food Defense rule, and so the Alliance is working to develop training materials for those areas as well. The animal food curriculum and the human food curriculum are completed. They're pretty extensive manuals. This is just an overview of the curriculum content. These manuals are available for electronic download free of charge. I gave you the link there to download the animal food manual. Again, the human food manual is available as well. Download the manual. I guess I'd caution you, don't hit print unless you really want to hit print. The animal food manual is 485 pages long. So just be aware of that. I wanted to emphasize again, if you are a covered facility here and are interested in this preventive control qualified individual training, you need to take that training through a course that's been registered with the Food Safety Preventive Controls Alliance and is delivered by an Alliance lead instructor. Again, if you're interested in this, you can look at the FSPCA website and get more information about that, or you can contact me. Courses began in June, and more are being made available over time. Let me switch gears and talk about the sanitary transportation of human and animal food rule quickly. We did a webinar with Grain Journal back on July 7th, I believe. Kind of ran through this rule, so I want to just highlight some of the information that we tried to provide at that time. This rule does establish requirements for 4 parties within the rule: shippers, loaders, carriers, and receivers. A shipper is somebody who is responsible for arranging for transportation of food. A loader would be somebody who loads food on a conveyance. The shipper and the loader may be the same entity. They may not be, but that's what a loader is. Carrier is the transporter, and then the receiver is the entity that receives the food. So this rule applies to truck and rail shipments, not waterborne shipments, not airborne shipments. And the requirements do apply to both interstate and intrastate activities. There are exemptions provided. This is a list of some of those. It's not an all-inclusive list. But activities performed by non-covered businesses are not covered, and FDA has defined a non-covered business as being an entity that has less than average revenues of $500,000 per year. So I'm going to expect that many of the carriers, for example, that we use in our industry maybe are not going to meet that threshold. They're going to be a non-covered business. Other entities that you deal with may also be non-covered businesses. Activities performed by a farm are exempt. So if you're a grain elevator, you're receiving grain from a farm who has arranged for the transportation activities. That farmer is exempt from the requirements of the rule. And then last, I've listed here activities associated with the transportation of food that's completely enclosed by a container. Things like a sealed bag, box, can, or jar, except for food that requires temperature control for safety, are exempt. Loading grain into a hopper and tarping it, that's not food enclosed in a container. Just wanted to point that out. If the food comes into contact with the conveyance, then it does not meet this exemption of being completely enclosed by a container. So the rule really establishes the primary responsibility for safe transportation of food is assigned to shippers. And so let me read this. Unless the shipper itself develops and implements written procedures to ensure appropriate conditions throughout the transportation operations, shippers must specify in writing to the carrier and when necessary to a loader all necessary design, sanitary, temperature control, if necessary, specifications necessary for the carrier's vehicle and transportation equipment to ensure that the product is transported in a safe manner. So the shipper has a lot of obligations under this rule. You can assign some of these responsibilities to someone else if they're willing to take those responsibilities on under a written agreement. Also, shippers are required to develop and implement procedures adequate to ensure that a previous cargo that was conveyed on the conveyance is not going to make the current load, current food, unsafe. I've had a lot of questions about this. For those of you who maybe followed the rulemaking process, FDA initially proposed that information would need to be made available about the last 3 loads that were hauled on a given conveyance. I think there was a lot of pushback on that, rightfully so, during the rulemaking process. And so what FDA did is they really went 180 degrees. Now they're saying that the shipper is required to implement procedures adequate to ensure that the previous cargo does not make the food unsafe. You don't even need to know what the previous cargo is now, nor does anyone need to share information with you about what the previous cargo was. So you have no obligation, if you are a shipper, under the rule to know what the previous cargo contained. You just need to assure that whatever was there last is not going to make the food that you load on the conveyance unsafe. So the comment was there's a current situation going on with peanuts where peanut residue went into a milling operation. There's been a lot of food recalled because the peanuts ended up in the flour, and it's caused allergic reactions to people that have that type of condition. And if you can't know what's on the previous load, how do you really take assurances or gain assurances that what you're receiving is going to be safe? And the point you raise is well made, and NGFA is very concerned about that. I'll get into that in a little bit, but we've entered into a pretty active dialogue with FDA about how this rule is constructed and how instead of enhancing food safety. It may actually inhibit food safety, because where in the past we've maybe had a voluntary exchange of information between parties associated with transportation of food. Now we've got a situation where if somebody aside from the shipper agrees to take some sort of responsibility, that places a regulatory liability or obligation on that party. And is that party really going to be interested in doing that? Particularly, I'm not sure who the audience is, but particularly railroads. Railroads are quite risk averse, and so do you think that a railroad is going to accept responsibility to perform various activities if they have no obligation to do so under the law? So it's a really good question. It's one that I think we're going to need to work through, or we hope to have further discussions on. Okay, I mentioned before that a loader is somebody, maybe not the shipper, who is responsible for placing food in a conveyance. These are the requirements there. For loaders, essentially a loader is responsible for following the specifications provided to them by the shipper and taking assurances that the conveyance is suitable for the food that's going to be put in it. That's the bottom line for the requirements for a loader. Here are the carrier responsibilities, and again, these are just limited to those that the carrier agrees to perform. So when the shipper and the carrier have agreed in a written contract to do these activities, this is when those activities are necessary. First, if they've agreed through a written contract that they're going to take on some sort of responsibility for the sanitary conditions associated with transportation, then they have an obligation to train their personnel on what those sanitary conditions need to be. But again, the training requirement is only there if there's a written contract between the shipper and the carrier. Also, if there's a written contract between the shipper and the carrier would be obligated to provide vehicles and transportation equipment that meets the shipper's specifications. They would be obligated to provide, if requested, information about the previous cargo that was hauled on the conveyance, and they would be required, if requested, to provide information to the shipper that describes the most recent cleaning of the conveyance. But again, they're only obligated to do these things if they've entered into a written agreement with the shipper stating that they'll provide that information. And here's the situation or the requirements for a receiver. Again, this would be a covered facility that receives food. Basically, the receiver is obligated to look at that food they receive, and if they determine that there's some condition that has rendered it to be unsafe, they need to take action to not further distribute that product until some determination has been made associated with it. That's really the only obligation that receivers have under the rule. I mentioned transloading operations before. FDA views transloading operations as being a transportation activity. So a transloading operation may have, how a transloader fits into this rule depends upon what they do. A transloader certainly would be a receiver. They also could be a loader. They also could be a shipper if they arrange for subsequent transportation of the food from their transloading operations. So if you're a transloader, you need to understand how these definitions work and where you fit into the definitions based on your activities. For example, a transloading entity is not considered to be a shipper if it simply holds the food pending transport and does not arrange for its transport. A shipper is somebody who arranges for the transportation. Also want to touch on the aspect of intra-company transportation activities. You may have a variety of locations within your company. You may have transportation activities occurring between locations. FDA has not exempted those transportation activities from the rule. Instead, what they say is that shippers, carriers, loaders, and receivers that are under the same ownership may rely on a common integrated set of written procedures for transportation activities as an alternative to the written procedures and requirements as outlined within the rule. So we're going to have to work out with FDA on what their expectation is in terms of this common integrated set of written procedures that could be used for intra-company transfer of food. That's something that we'll need to figure out over time. Just a few more perspectives about the sanitary transportation of food rule. I think I've already covered these. We're really concerned about the lack of carrier responsibilities and what that could do to inhibit communication between transportation entities. Again, I'm not sure that how this will play out in the trucking arena, but we've already had members contact us that say their rail carriers are not willing to share prior loads, prior cleanings, where in the past they were willing to do so. So we've already seen situations where railroads, at least, have become risk averse to the regulatory obligations that would be placed upon them if they enter into written agreements with shippers. We think that's concerning. Again, we met with FDA. We're going to be continuing to have that dialogue with them, and we'll make our members in the industry aware of what happens moving forward in that area. Last couple slides, compliance dates. Main reason I put this up there was just simply to say that even the compliance dates are complicated. I've got compliance dates listed here for animal food rules. If you're covered by the CGMP and Preventive Control Rule, the CGMP part is staggered from the Preventive Control part. Then we've got compliance dates established for large businesses, small businesses, very small businesses. You can see those. The sanitary transportation rule, if you're a large business, which would be 500 employees or more, the compliance date's April 6th. So the clock's ticking. We're going to have to work with FDA to get clarification on some of what these requirements mean. If you're a small business, which would be less than 500 employees, you got two years to comply, April 6th, 2018. Last slide, I think. Just want to make you aware that we have a number of resources on our website to help inform the industry about these FSMA-related rules. This is a list of some of the resources we have. Provide summary of all the compliance dates, things of that nature. So I'd encourage you, if you just want a broad overview, kind of a high-level overview of what these requirements are and how they apply, please take a look at our website. I think we have some good information there. So with that, I'm not sure we're winding down on time, but if there's any time for any questions, if any folks have any. The question was, okay, you got a transloading operation that's receiving product by rail or truck, and that's loading product onto a barge. And so, yeah, you are a receiver under that definition. You receive the food. But if the subsequent transportation activities are waterborne, then that's exempt from the rule. In the scenario that you described, you're receiving food, truck or rail, and then the food leaves the transloading operation on a barge. The only definition met within that type of scenario would be the receiving, your receiver. Okay, thank you very much.